Welcome to Legal Listening, where audio obiter is our thing. We're Carly and Zach, and we're so glad you're here with us today.
So today on the podcast, we're actually going to have, this is going to be kind of a two-parter because there's actually two separate decisions released for this case. So the case that we're going to be discussing is the Queen and Doering, which is an Ontario Superior Court of Canada decision. The decision at trial was released in 2019, and the decision at sentence was released in 2020. And before we go into it, I do want to offer up a content warning. This case has some pretty horrific details, some very graphic and upsetting material, and make sure you take care of yourselves. This is definitely not for everyone, and I would advise if you're going to listen to it or read it, definitely take some breaks and don't be afraid to walk away from it for a little bit. So, Carly, have you heard of this?
I have never heard of this decision. I feel so non-crim focused right now, but no, I'd never heard of this until you sent it to me.
It actually came up over Twitter because the sentencing decision, Justice Pomerantz from the Windsor Superior Court of Justice was actually the justice presiding over this case. It takes place in London, Ontario. But the sentencing was actually broadcast over YouTube for everyone to hear. And then the reasons were released the same day in the afternoon. So in short, this case deals with the spoiler alert for the sentencing, I guess, in the trial decision, but it deals with a police officer convicted of failing to give the necessities of life to someone under their charge. And in this case, it was an Indigenous woman who was suffering from drug overdose. So like I said, it's some very tough material to read. But again, one, I love the writing of Justice Pomerantz. I think it's very succinct, to the point, and she doesn't mince words. And no. I think that's very important from the bench.
Oh, yeah. I mean, this is low-key a Justice Pomerantz stan podcast. So we've read many of her decisions, honestly, because they're very easy to read. It's definitely a factor, and we always find her decisions amazing. And she has obviously comes to the school, and we've had experiences with her, and we think she's lovely. So we do read her decisions. But honestly, now that you mentioned the facts, I do know what this case is, because I, too, had been reading about it on Twitter. I couldn't recall the name of the officer, but I do remember this, and that the sentencing was broadcast live on YouTube, which is another... We've been talking lately about COVID and public access, and this is definitely a way to make sure that people see decisions, is to have sentencing broadcast on YouTube.
Yep, I remember this happened with, I believe it's the DeFonte Miller case as well.
Yep.
The sentencing of those police officers, I believe, was also done on YouTube as well. I think that in terms of like the open court policy, just as a quick aside, I think maybe this is the way that the courts can start to go. It's weird because we have, if anyone is non-Canadian, we have very strict rules about like recording in courtrooms.
Yes.
And like transmission and copying and stuff. Basically, you can't record anything in a courtroom in Canada. It's the law. You can't take pictures. Your cell phone has to be away, all this stuff. So recording on YouTube presents particular issues. I'm not going to get into them. Yeah. Not my bag, really. But switching gears back to the case, it's a very interesting case, especially if you want to start to understand what systemic racism looks like, because I think this case provides a very clear painted picture of systemic racism in Canada. I think if you want to see like in particular, the nexus between policing and Indigenous individuals, this is a case worth reading if you really want to grapple with it. But like I said, it is unfortunately very disturbing and very sad what happens.
Yeah, and I know we recently recorded our introduction on the Queen and Barton, and I know we were talking about a bunch of similar sort of through lines, unfortunately, between a lot of the decisions in Canada in terms of racism against Indigenous people. So it's something we've definitely discussed on the podcast before, but I think this is the first time we've sort of specifically addressed it in terms of the relationship between Indigenous people and the police, which is, of course, a very complicated, storied, last 400 years. Like it's a lot.
Yes, yeah. There's a lot in this case, and I'm sure, or I'm confident that this is going to be a case. Depending on I'm confident it's also going to be appealed, but if the appeal affirms the trial decision, I would hope that this case is one that is taught across law schools in Canada, because I do think it demonstrates, when discussing what systemic racism looks like, this case does a very good job of breaking down the events and how, even though perhaps the intentions of the officer were not outwardly racist, I think the discussion of systemic racism is worth having, especially in the context of the facts of this case.
Definitely. Racism isn't always just like foaming at the mouth, people running around screaming things, right? Like a lot of the most damaging acts of racism happen in ways that are quiet.
Yep, and that's it. So I hope you guys enjoy this case. And like I said, take care of yourselves. Enjoy. The Queen and Doering. Decision by Justice Pomerantz of the Ontario Superior Court of Justice. On September 7, 2016, Deborah Christian, Miss Christian, a woman of Indigenous heritage, died while in police custody. She had ingested a toxic level of methamphetamine, resulting in a heart attack. The tragedy of her death is compounded by the fact that it might have been prevented. Timely medical intervention might well have saved her life. Regrettably, that did not occur. The Crown introduced a video of Miss Christian being brought into the Ontario Provincial Police OPP detachment shortly before her death. It is silent witness to the gravity of her condition at the time. She is limp, silent, and demonstrating no signs of movement as she is dragged across the sally port and into the cells. The OPP summoned EMS, but by the time they arrived, it was too late to save Miss Christian's life. During the critical time period, Miss Christian was in the custody of the accused, Constable Nicholas Doering, Constable Doering, of the London Police Service, LPS. He arrested her on an outstanding OPP warrant and eventually transferred her to OPP custody. The Crown alleges that Constable Doering's failure to obtain medical assistance from Miss Christian amounted to a failure to provide the necessaries of life, contrary to Section 215 of the Criminal Code, Revised Statute of Canada, 1985. The Crown further alleges that, when Constable Doering transferred custody of Miss Christian to the OPP, he knowingly provided false and incomplete information about her medical condition. This, it is alleged, demonstrated a wanton and reckless disregard for Miss Christian's life and establishes commission of criminal negligence causing death, contrary to Section 222 of the Criminal Code. The Crown contends that Constable Doering's conduct represents a marked and substantial departure from the standard of care of a reasonable, prudent police officer. Constable Doering testified at trial that he did not perceive that Miss Christian required medical attention. He believed that she was just experiencing the effects of methamphetamine and needed to, quote, ride out the high, end quote. He had received confirmation of that position from an EMS supervisor earlier on in the detention. The defense argues that the accused made an error in judgment, but an error that was reasonable in light of his past experience with methamphetamine users and the conversation with the EMS supervisor. The accused denies that he deliberately misled OPP officers during the transfer of custody. He argues that the Crown failed to establish a marked and substantial departure from the standard of care of a reasonable, prudent police officer. I have carefully considered the whole of the evidence called at trial, the exhibits, and the agreed-upon facts. It is important to remember that hindsight is 20/20. We now know that Miss Christian was in dire need of medical attention. However, I must focus on what was known and apprehended by Constable Doering at the time of the events. What did he observe? What was he aware of? What did he make of those observations? Were his perceptions and resulting actions consistent with those of a reasonably prudent police officer in similar circumstances? Or did he fall below the minimum standard of care? I will begin by outlining the evidence at trial. I will then turn to the governing legal principles. Finally, I will apply those principles to the facts of this case. Evidence at trial, admissions, and agreed facts. The accused admitted various facts at trial, including the following. 1. While in the custody of Constable Nicholas Doering on September 7, 2016, Deborah Christian Elijah was unable to provide herself with the necessaries of life. 2. Methamphetamine is a powerful stimulant drug which floods the user's brain and body with the adrenaline hormone. Users often experience side effects which can include confused cognitive functions such as paranoia, elevated sensory stimulation, and agitations and restlessness. 3. Although there is no antidote to counter or reverse its effects, medical treatment and interventions are available for persons who have ingested methamphetamine. Medical treatment usually involves monitoring and treating as required the user's symptoms in a hospital until the drug's effects on the body have dissipated. 4. Not everyone who experiences side effects as a result of using methamphetamine require medical treatment or intervention. 5. For users who require medical treatment and intervention, the sooner they receive such an intervention, the greater the chance of success, recovery, or survival. 6. Due to the effects of using methamphetamine, Deborah Christian Elijah required medical treatment and intervention at the time of her transfer to the Ontario Provincial Police in the Tim Hortons parking lot on September 7, 2016. 7. From the time of her arrival at the Elgin OPP detachment onward, Miss Christian was in a critical state and required urgent medical intervention and treatment. 8. The delay in providing her with medical attention and treatment impacted her chance of survival, although it is difficult to determine to what degree. Her death, however, was not inevitable. In other words, had she received medical attention or treatment prior to the involvement of the paramedics at the Elgin OPP detachment and medical staff at the St. Thomas Elgin General Hospital on September 7, 2016, she might have survived. The events of September 6, 2016. Miss Christian initially had contact with the LPS on September 6, 2016. Constable Jared Park, Constable Park, was dispatched to attend at the intersection of Warncliffe Road and Highview Avenue in the City of London. The dispatch was a, quote, check welfare call, end quote, which directs officers to try to locate a subject and determine if he or she is in distress or otherwise needs attention. Constable Park arrived at 12:03 p.m. and was flagged down by 2 citizens. He observed Miss Christian, at which time she ran in the direction of a strip mall. She appeared to be confused, nervous, and was constantly looking around. The officer believed that she was under the influence of a drug. He approached her and asked her name, to which she replied, quote, Deb, end quote. She seemed unable to sit still, and the officer came to believe that she had ingested crystal methamphetamine. She was speaking but did not make sense. The officer called for an ambulance at 12:05 p.m., telling dispatch that, quote, this female is just, reacting to some crystal meth. Can we just have an ambulance come by and see if they can check her out? End quote. While waiting for the ambulance, Constable Park spoke with Miss Christian. He asked her where she was going, where she was coming from, and how much sleep she had in the past day or two. She was running from place to place and, at one point, hopped into the front seat of a taxicab that already had a fare in the back. The officer asked her to sit in his cruiser and ran a check on her name. He learned that the OPP had an outstanding warrant for her arrest on a charge of failing to comply with a recognizance. He arrested her on the warrant, cautioned her, and waited for the ambulance. The ambulance arrived and transported Miss Christian to the hospital. The officer remained with her in triage until he was notified that the OPP would not be coming to take her into custody. Initially, indications were that the OPP would be coming to the hospital. Constable Park then had a conversation with Sergeant Andy Doty, a team leader at the Elgin detachment, who advised that the OPP would not attend London to wait at the hospital. They would not return on their warrant until Miss Christian was, quote, medically cleared, end quote, by the hospital. Upon receiving this information, Constable Park released Miss Christian from his custody and left her at the hospital. He later learned that she left the hospital against medical advice. When asked why he called for an ambulance, Constable Park advised that Miss Christian was acting erratically and running into traffic. He did not initially have any grounds to arrest her, but he could not just drive away. He testified that he did not think that it was a medical emergency. He testified that it is a common occurrence for officers to encounter individuals who have consumed methamphetamine, and that those individuals are not routinely medically assessed before being placed into custody. According to Constable Park, Miss Christian was extremely intoxicated, but her level of intoxication was average compared to what the officer encountered on a regular basis. Nicholas Vernon, an EMS officer, responded to the call for an ambulance on September 6, 2016. He testified that it is quite common for EMS officers to be called to deal with a person intoxicated by drugs. When responding to such calls, the EMS officer is required to take the individual to the hospital unless they refuse to go. Events of September 7, 2016. The initial 911 calls. On September 7, 2016, various 911 calls were placed about Miss Chris John's behavior at the intersection of Highbury and Trafalgar Streets in London. At 5:27 p.m., a call came from Ahmed Fayed, Mr. Fayed, a civilian witness at the scene. LPS dispatch sent a call for a, quote, check welfare in progress, end quote, stating that a caller was concerned about a female walking on the road and trying to get into cars, and that he was trying to restrain her at a Petro-Can gas station until officers arrived. At 5:30 p.m., a female called 911 to report a woman had been running through traffic at the intersection of Highbury and Trafalgar, and it looked like someone was holding her on the ground. At 5:32 p.m., a 911 call was placed by a woman referred to at trial as the woman in the van, who reported that someone, quote, tried jumping into my van while I'm driving down the road, end quote. She was advised that there was an older gentleman, quote, who had pinned her to the ground right now and trying to keep her safe, end quote. At 5:33 p.m., Anna Parker, aka Miss Parker, the second civilian attending to Miss Chris John, called 911 because she saw a police car drive by and thought they might have missed the location. At 5:34 p.m., an employee of the Petro-Canada gas station on Highbury Avenue called and reported that there, quote, there is a crackhead outside the store, end quote, and at 5:37 p.m., the sister of the woman in the van called for an ambulance to assist because her sister was having a panic attack. Doering and Steves are dispatched. At 5:34 p.m., Constable Doering was dispatched to attend at the scene. Constable Steves, aka Constable Steves, was dispatched to attend at 5:35 p.m. The dispatch provided that EMP from Petro says that Femme is a crackhead, had to run into the store prior, now laying down outside. In response to the dispatch, Constable Park radioed at 5:34 p.m. That kind of sounds like the girl I had yesterday, Deborah Elijah. She's at 1063, quote, has a warrant, end quote, with the OPP. She's also HIV and Hep C. At 5:36 p.m., Constable Doering queried Deborah Chris-John Elijah on police systems, RMS, and CPIC. He arrived at the Petro-Canada parking lot at 5:40 p.m., with Constable Steves following at 5:45 p.m. Doering arrives at the scene. At 5:40 p.m., Doering arrived and radioed, she's just being held down on the grass on the northwest corner of the Petro lot, end quote. According to Mr. Fayed, one or two police officers arrived at the scene. He heard one officer get out of his cruiser and call Miss Chris John by name. He heard the officers say that she was wanted by the OPP. He arrested her and placed her in the back of a police car. Miss Parker testified that she heard the officer say, quote, yeah, well, we know her well. We had her with us on Wednesday. She's probably just cracked out, end quote. She heard the officer say, quote, Deborah, there's a warrant out for your arrest, end quote. He asked her to turn over on her stomach and handcuffed her. The woman was agitated but cooperative. The officer took down Mr. Fayed's name, but when Miss Parker asked whether he needed her contact details, he responded, quote, I think we're good, end quote. Miss Parker then went over to the woman in the van who had called 911, who was very distraught. She stayed with that woman until her sister arrived. She did not recall seeing an ambulance at the scene. Thereafter, the following communication took place between Constables Doering and Steves on the mobile data terminal. 5:49 Steves. Just watch she doesn't boot out your window. Your back left window is open. FYI, the rain. 5:54 Doering. Roger, thanks. She is so high on meth. The CPIC message, OPP warrant. At 5:50 p.m., Constable Doering posted the following message to Prime ORI handle. To whom it may concern, we have arrested a female, Deborah Chris-John, DOB, on your outstanding warrant for breach of recognizance. Please let me know if you will return. We will be able to meet you halfway if you would like. Be advised that Chris-John is high on crystal meth. However, it does not appear at this time she requires to be cleared medically at the hospital. Thanks. attendance of Sean Hill. Sean Hill, aka Mr. Hill, is an EMS supervisor. On September 7, 2016, at 5:41 p.m., he heard a dispatch, quote, "Code 3 for behavioral problems," end quote. He took it upon himself to respond at the Petro-Canada gas station at Highbury and Trafalgar. When he arrived, he saw 2 London police cruisers parked at the gas station. He parked just in front and to the east. He saw Constable Doering sitting in the driver's seat of his vehicle and Constable Steeves in his vehicle. Mr. Hill left his vehicle, as did Constable Doering, and they had a brief conversation. Doering's driver's side door was open, and Mr. Hill was standing at the front of the officer's vehicle. He noticed a female in the back seat of the cruiser, whom he observed through the front windshield and protective plexiglass barrier. Mr. Hill recalled that the female was acting aggressively, throwing herself against the passenger side door and yelling profanities. She was upright. He heard her speaking. She did not appear to have any trouble breathing. She was conscious. There was no blood or vomit. He estimated her to be at a level 15, the highest level of consciousness on the Glasgow Coma Scale. In his testimony in chief, Mr. Hill testified that he asked Constable Doering whether he wanted EMS to assess the patient in the back of the cruiser. He testified that Constable Doering said that, based on her behavior, she would not tolerate any form of assessment. According to Mr. Hill, Constable Doering further said that she was wanted on outstanding warrants, and he was waiting for direction on what the OPP wanted LPS to do. Mr. Hill testified that there was some discussion about what a hospital might do for her and the potential for abnormalities in her vital signs. He said that Constable Doering told him that if he changed his mind or had a further need for EMS, he would call him back. From there, Mr. Hill went to speak to the 2 paramedics who had then arrived with an ambulance. Constable Steeves was talking to Sarah May and Devin Mason, the paramedics. According to Mr. Hill, Constable Steeves told him that LPS did not require the woman to be assessed and that he was clearing the scene. Mr. Hill recognized Constable Steeves from a media release. In cross-examination, Mr. Hill was confronted with statements he made to the Ministry of Health MOH investigators, the SIU investigators, and his testimony at the preliminary inquiry. It came to light that Mr. Hill had been scrutinized for certain aspects of his conduct. He failed to fill out an ambulance call report in a timely way. He also failed to notify the communications center of his attendance at the scene. Mr. Hill's testimony was inconsistent with his other statements. For example, Mr. Hill told the MOH investigators that he did not recall any conversation with the paramedics, yet he recalled a conversation when he testified at trial, claiming that his memory had gotten better. Mr. Hill testified that, when he got the dispatch call, he did not know who the patient was that he was supposed to assess. He testified that he thought that the intended patient was the woman in the back of the police cruiser. He similarly told the MOH investigators that the intended patient was the person believed to be breaking into cars. However, in his statement to the SIU investigators, Mr. Hill told them that the patient to be assessed was the woman in the minivan. During cross-examination, Mr. Hill acknowledged that, if he told the MOH and that the patient was the woman in the minivan, he could face negative findings for his failure to assess her. Mr. Hill testified that he did not offer to assess the woman in the back of the cruiser because it was more appropriate for the paramedics to do so. However, he acknowledged that he had the same training as the paramedics and that policy required that the first responding paramedic complete the initial assessment. In an email sent on September 12, 2016 to his supervisor, he stated that he had offered to assess the woman or alternatively advise the officers that the paramedics could do so. Mr. Hill acknowledged that it is difficult to get a full set of vital signs on a person under the influence of methamphetamine. The drug can often lead to irregular vital signs. He acknowledged that, if he had assessed Miss Christian and discovered irregular vital signs, he would have been required to take her to the hospital. Ultimately, Mr. Hill agreed that when asked by Constable Doering what he could do, he told him that all he could do was check vitals and they would be, quote, out of whack, end quote, due to ingestion of the drug. He did not recall telling Constable Doering that, if Miss Christian went to the hospital, she would just sit there for hours and be monitored, but he acknowledged that it was possible that he had said that. Paramedics at the scene. Sarah May, aka Miss May, one of the paramedics who attended at the scene, testified at trial. Her partner, Devin Mason, was too ill to testify, but her preliminary inquiry transcript was admitted into evidence with the accused's consent. Miss May had no contact with Miss Christian. She was in attendance to assess the woman in the minivan who had reportedly had a panic attack. Miss May reported a conversation with a police officer while at the scene, in which the officer told her that a lady high on crystal meth was trying to open some doors, but that everyone was fine. She believed that the officer in question was the one who had been sitting in the cruiser with the woman in back. Miss May testified that, before she left, she said to the officer with reference to the woman in the cruiser, quote, "She doesn't need to be assessed," end quote, to which the officer responded, quote, "No, we're good to go," end quote. There is some question about what Miss May said to the officer before leaving the scene. In prior statements, she recalled asking, more generally, whether she could be of assistance. In any event, nothing turns on this because I find Miss May was speaking to Constable Steeves, not Constable Doering. She said that she was speaking to the officer who had the woman in the back seat. That was Constable Doering. However, she also testified that the officer had, quote, "darker and longer flippy hair," end quote, and not a, quote, "buzz cut," end quote. That clearly describes Constable Steeves. Moreover, Mr. Hill testified that it was Constable Steeves who had walked over to the area where the ambulance was. I find that, on this point, Miss May, while offering her honest recollection, is mistaken as to which car the officer came from. Constable Doering played no part in the conversation that she had at the scene. The transfer of custody to the OPP. While traveling to the transfer point, Constable Doering engaged in the following communication with Constable Park over the mobile data terminal. Park, "Was that Deb?" Doering, "Yeah, high on meth." Park, "Yeah, she was a mess yesterday." Park, "OPP was very annoying to try and deal with." Doering, "Same today, but OPP's taking her." Doering, "I'm driving her to ST." Park, "I didn't know who she was when I started dealing with her, so I called for an ambulance, and then I found out she was wanted, but they didn't want to get." Doering, "Got ya." Dispatch, "That location works for them. They are dispatching to meet you at Tim's now." Doering, "She can stay in custody now. She's wanted by Brantford too." Park, "Yeah, I saw that." Doering, "Thanks for the info, FYI. Made it so much easier to know who she was ahead of time." Park, "Yeah, no worries. As soon as I hear the desk, I figured it was her, and she was telling me yesterday she has a sister on Trafalgar." Doering, "Perfect." Park, "Yes, sir. Good that she will be out of our hair now, though." Doering, "Yep." Dispatch, 13B transporting Femme to Highbury Ron McNeil to meet OPP. 13B was Constable Doring's call sign. Doering arrives at the Tim Hortons. Constable Ashley Billing, Constable Billing, is an officer with the Elgin Detachment of the Elgin Middlesex OPP. On September 7th, 2016, she was assigned to deal with a warrant. At 6:07 p.m., she spoke to the communications center about the warrant confirmation for Deborah Christian. She was told that London police had her in custody and that they were willing to drive her halfway. She said that she would check with the sergeant and call back. She was told, quote, "And just for the sergeant's knowledge, she is currently high on meth, but they don't think she needs to be hospitalized," end quote. At 6:20 p.m., Constable Billing advised the communications center that they would meet London police halfway on Wellington Road just south of the 401 at the McDonald's restaurant. At 6:24 p.m., the communications center was advised by Terry from London Police that London was already halfway to the location and that they're going to meet at a Tim Hortons restaurant located at Highbury Avenue and Ron McNeil line, rather than at McDonald's. Constable Billing was advised of the new meeting place, and she was left with Constable Mark McKillop, or Constable McKillop, at approximately 6:17 p.m. They arrived at the Tim Hortons at 6:37 p.m. and pulled up 2 parking spots away from Constable Doring's cruiser. Constable Billing went over to speak to Constable Doering, whom she had not met before. He advised her that Miss Christian was in the vehicle and that London police had picked her up when she was in traffic opening doors. He advised that she was high on meth and had been medically cleared. He advised that she was hepatitis C positive and violent towards police. Constable Billing understood from this conversation that Miss Christian had been assessed and did not require hospitalization. In cross-examination, she acknowledged that she might have been told that Miss Christian was cleared by EMS, but did not know if that was at the hospital or not. She also agreed that she might have mixed up what Constable Doering said and what had been said over dispatch. Constable McKillop testified that, while he did not recall the exact words used by Constable Doering, he understood that, while in London, EMS had looked at Miss Christian and assessed that she did not need to be taken to the hospital. He understood that they took a look at her and determined that she was high and that they could not do anything further. During Constable Billings' conversation with Constable Doering, she could see Miss Christian in the back of the car. Miss Christian was lying down on her right side across both back seats and was handcuffed. When Constable Billing opened the door, she could see that Miss Christian was making a moaning sound and shaking. Constable McKillop testified that Miss Christian's feet, quote, kind of kicked towards me, end quote, when they were trying to get her out of Constable Doering's cruiser. Constable Billing testified that Constable Doering told her that, quote, this was how she was since he's had her, end quote. In cross-examination, she acknowledged that he might have said that she had been behaving like that since coming into his custody. Constable Billing believed that she was under the influence of a drug and that her symptoms were a function of that. Constable Billing went to the rear driver's side door to introduce herself to Miss Christian and explain that she was being taken into OPP custody. Miss Christian did not respond or do what she was asked of her. All she did was moan. Constable Billing waited to give her an opportunity to comply, but she still did not do so. Constable Billing construed this as willful non-compliance. Constables Billing and McKillop got her to her feet on the ground outside of the cruiser. Each took one side of her and helped her out of the vehicle. Miss Christian was partially weight-bearing. Constable Billing used one hand to assist her, but used the other hand to shield her face in case Miss Christian became violent. Constables Billing and McKillop moved her around to the back of the car where Constable Doering's handcuffs were removed and replaced with OPP handcuffs. Constable Billing spoke to Miss Christian throughout this process but did not get any response. From there, Constable Billing and McKillop held her and walked her to the OPP cruiser. Constable Billing believed that she could walk on her own but was refusing to do so, so she and the other officer walked her there. She was not speaking but continued to moan in an almost rhythmic way. When they arrived at the OPP cruiser, Constable Billing told her, quote, we need you to get into the cruiser, end quote. She did not comply. Constable McKillop put her into the cruiser, at which point she lay down on her left side. Constable Billing advised her that she was under arrest, advised her of her rights to counsel, and administered a caution. There was no response, just persistent moaning. Constable Doering sent the following message upon leaving the transfer point. Doering, Christian high on drugs, no concerns for welfare, NFA. Arrival at the OPP detachment. Constables Billing and McKillop drove to the Elgin detachment. During the drive, Miss Christian continued to make moaning sounds and, every once in a while, moved in a jolting way. Shortly after they arrived, at 7:11 p.m., Constable Billing opened the rear passenger side door and asked Miss Christian to get out of the car. She remained in a prone position, the same position she had been placed in at the transfer point. Both officers spoke with her, but she was still just moaning. Constable Billing believed that she was refusing to comply with their commands. When asked why she perceived non-compliance, Constable Billing responded that this was based on the information she had been given. She dealt with the prisoners on a daily basis and believed that Miss Christian did not want to enter into custody. Constables Billing and McKillop got Miss Christian to a standing position and walked her into the detachment. She was not assisting them in any way. She was no longer weight-bearing. The officers were effectively carrying her at this point. Miss Christian was carried through the breezeway into the booking area in cell number 1. She was placed on the bed so that her cuffs could be removed. Sergeant McMorrigan then took the mattress off the bedding block so that she would not roll off the concrete bed. She was entirely unable to assist the officers at this point, and they placed her in the recovery position. Constable Billing testified, at this point, Miss Christian was non-responsive. She was not moving. She was still moaning, but not as loudly as in the cruiser. According to Constable McKillop, she was not moving at all. She was making very little noise, and she was not at all weight-bearing. Her color looked, quote, off, end quote. A guard was called in to monitor Miss Christian while in custody. She was to be under constant supervision because it was known that she had consumed drugs. She was lodged in the cell at 7:20 p.m. EMS is called by the OPP. Constable McKillop testified that Miss Christian seemed very intoxicated. He spoke with Sergeant McMorgan, who was concerned about Miss Christian's condition. According to Constable McKillop, there were two choices. They could either place her under constant supervision or contact EMS. The officers decided to call EMS, but, somewhat remarkably, did not perceive that they were dealing with a medical emergency. The call was a code 3, which conveyed, quote, "No lights and sirens, obey all traffic laws," end quote. The request was conveyed by Constable McKillop to OPP Communications at 7:28 p.m. as follows. "Can you send a 1052 over to our cells? No rush, no lights or sirens or nothing. It's just for someone we believe to be used meth and we want them checked out and make sure they're okay to be in cells." The communication center contacted EMS to advise that there was a woman in custody and that, quote, "We just want her checked out to make sure she's okay," end quote. EMS asked if she was awake and breathing normally, and the OPP responded, quote, yeah, end quote. EMS asked if there was a possible overdose. OPP responded, quote, no, they don't want you coming lights and sirens or anything like that, end quote. OPP said that, quote, "Before they lodge her in cells, they just want her checked out," end quote. EMS arrives at the OPP detachment. Rob Redman, aka Mr. Redman, and Kimberly Snell, aka Miss Snell, both EMS paramedics, arrived at the Elgin OPP detachment in response to the call. They were dispatched at 7:30 p.m. and arrived at 7:36 p.m. Miss Christian was observed in the cell, supine on the floor, with no active movement, no spontaneous limb movement, no blinking of the eyes, and no sound. Normally, a patient who is conscious or semi-conscious will move limbs and blink eyes. Mr. Redman opined that Miss Christian would register as a 3 out of 15 on the Glasgow Coma Scale. He observed that there is no measurement lower than 3. The paramedics determined that Miss Christian's heart rate was at 171 beats per minute, a rate that could not be sustained for long. Her respirations were irregular and shallow. Her blood pressure was high. Her eyes were fixed, dilated, and the corneas were dry, signifying that the eyes had been open for some time. It was clear that Miss Christian was unconscious and that there was a significant risk of cardiac arrest. She was placed in an ambulance and transported to the hospital at 7:52 p.m. Miss Snell testified that when the ambulance arrived, the officers told them that they had a female that they wanted assessed, but she did not perceive any sense of urgency. It was only as they were leaving the detachment that the officers, quote, "had more sense of the gravity of the situation," end quote. Miss Christian is taken to the hospital. Constable Billing was assigned to follow Miss Christian to the hospital. She arrived at the hospital at 7:58 p.m., and she stood outside the room where Miss Christian was receiving medical attention. The door to the room was opened, and someone asked for assistance with compressions. Constable Billing went into the room and took over the administering of the compressions, but Miss Christian did not respond. Cause of death. The report of the pathologist, Dr. M.J. Shukram, or Dr. Shukram, was entered into evidence on consent. Dr. Shukram identified the immediate cause of Miss Christian's death as methamphetamine toxicity, which led to a cardiac arrest. Mary Elliott, aka Miss Elliott, a forensic toxicologist, testified about the analysis of blood and urine samples taken from Miss Christian after death. Testing of the blood revealed 0.41 milligrams of methamphetamine per liter of blood and 0.16 milligrams of amphetamine per liter of blood. The level of amphetamine suggested that it was a metabolite of methamphetamine, though it is also possible that amphetamine was ingested. Miss Elliott testified that, when it comes to methamphetamine, what is toxic for one person may not be toxic for another, although death is more likely to occur at levels above 0.5 milligrams per liter. Police policies. The Crown called Inspector Brian Dwayne Price, aka Inspector Price, to testify about LPS policies and procedures. Inspector Price testified about policies governing the arrest of persons with warrants and the procedure to be followed. Inspector Price testified that officers are not specifically trained that certain signs require a prisoner to be taken to hospital. As he put it, there are expectations and it is about monitoring. Officers are given training in first aid and mental health issues. Inspector Price was asked about an LPS policy, Part 9, Chapter A, 2, B, 7, which in 2016 provided as follows. When the medical condition of a prisoner is in doubt, e.g. under the influence of alcohol or drugs, immediately arrange transport for the prisoner to the nearest hospital. Inspector Price testified that he believed that this particular policy had been revised after the death of Miss Christian, such that the words, e.g. under the severe influence of drugs, alcohol, had been removed. Inspector Price also testified that there are between 1,500 and 2,000 pages of policies that officers are required to review, and that one would not expect an officer to retain all of this information. He testified that he himself was unaware of certain policies regarding arrests made on warrants held by other police agencies. The accused's testimony. Constable Doering testified at trial about his interaction with Miss Christian. He testified that, while she was proceeding to the Petro-Canada gas station at the intersection of Trafalgar and Highbury, he had a telephone call with Mr. Fayed, who had called 911. Mr. Fayed had told him that he was holding the female down and that the officer needed to get there quickly. Constable Doering believed that he could hear sounds of a struggle in progress. When Constable Doering arrived, it looked as though Miss Christian was being held down, but as he approached, he saw that she was laying on her right side and that no one's hands were on her. He observed that she was fidgety and moving her arms around. Her eyes were open and she looked, quote, spaced out like she was high on meth, end quote. Constable Doering walked around to her right side, took her left wrist, and handcuffed it. Miss Christian rolled onto her stomach and he handcuffed both hands behind her back. He told her to get up and she complied. Constable Doering arrested her on the outstanding OPP warrant. He opened the rear passenger door of his cruiser and placed her inside, shutting the door. She was cooperative. Constable Doering then spoke to Mr. Fayed, who told him that Miss Christian was high on drugs and was acting in an unusual way, including running in and out of traffic. Constable Doering moved his vehicle off the roadway and into the Petro-Canada parking lot. He backed his car in so that it was facing northbound. Not long after, Constable Steeves pulled in next to him, facing southbound. On 3 separate occasions, Miss Christian told him that there were bombs in the back. On each occasion, he was able to calm her down by telling her that there were no bombs. Mr. Hill arrived in his SUV. According to Constable Doering, Mr. Hill walked over to his cruiser and stood by the open driver's side door. Mr. Hill was standing at the front of his cruiser, looking in, and he could see Miss Christian through the front windshield and the plexiglass. At this time, Miss Christian was no longer calm. She appeared angry and was moving aggressively in the back of the cruiser. In cross-examination, Constable Doering agreed that Miss Christian was erratic and delusional while at the Petro-Canada station. He agreed that her level of consciousness, if 10 is fully alert and awake, was a, quote, 4, end quote. It was obvious to him that she was not in good health, but he explained that this was the effect of long-term drug use. He testified that dealing with people high on meth is an everyday occurrence, as is the placement of persons high on meth into custody. In his cross-examination, Constable Doering agreed that Miss Christian was very high on methamphetamine. Yet, in a letter he wrote to the SIU responding to questions they had posed, he stated that Miss Christian was in an average state of intoxication. He explained this by saying that, while she was very high, this was average compared to other individuals whom he had encountered in his day-to-day activities as a police officer. According to Constable Doering, Mr. Hill asked if they needed assistance. Constable Doering told Mr. Hill that he believed that Miss Christian was high on meth and questioned whether she would tolerate an assessment. He asked Mr. Hill if there was anything they, EMS, could do. He testified that Mr. Hill told him that they could check Miss Christian's vitals, but they would be out of whack due to the drug. Constable Doering asked whether she could be taken to the hospital, and Mr. Hill responded that she would just sit there for hours while being monitored. Constable Doering perceived that Mr. Hill was sharing his honest beliefs. At one point, Constable Steeves left his cruiser. He stood with Mr. Hill and Constable Doering briefly and then went over to where the paramedics were attending, near a woman crying outside a van. Constable Doering did not go over to the van as he believed that Constable Steeves was dealing with that situation. Constable Doering was asked what his perception of Miss Christian's condition was at the point in time. He testified that he interpreted his conversation with Mr. Hill as confirming that there was no need for Miss Christian to be assessed and that she would have to, quote, ride out the high, end quote. This was consistent with his own perception based on his experience as a police officer. During his testimony, Constable Doering referred on several occasions to his experience with methamphetamine users, including his time as a cadet when he worked in cells. He testified that he routinely engaged with people who were high on methamphetamine, in cells and later on the street. He testified that Mr. Hill's, quote, advice enhanced my belief that she was just high and would have to ride it out, end quote, and that, quote, she was safe to go into custody where she would be monitored, end quote. Constable Doering went back to the cruiser and advised Miss Christian of her right to counsel and administered a caution. When he asked her, quote, do you understand, end quote, she responded, yeah. But when he asked her if she wished to call a lawyer, she did not respond. He asked 3 times, but she did not answer the question. At the end of the caution, when he asked her if she wished to say anything, she said, quote, no, end quote. Constable Doering had sent a CPIC message about the OPP warrant. He learned that the OPP would return on the warrant and that they would meet him about halfway. The original transfer point was McDonald's just off the 401, but Constable Doering changed that location to the Tim Hortons at Highbury and Ron McNeil. On his own initiative, he began traveling southbound on Highbury. He testified that it seemed more reasonable to take Highbury because it had a posted limit of 100 kilometers per hour. During the drive to Tim Hortons, Constable Doering observed that Miss Christian was sliding down in her seat. Each time she did so, Constable Doering told her to sit up, and she did. He observed that her eyes were open and that her head was up. While they were traveling, she said something in the back of the cruiser. Because the window was open, the sound of the wind made it impossible for him to hear what she said. He pulled over at one point and checked on her in the back of the cruiser, but only because he was concerned that she might try to slip out of the handcuffs. He was aware that people sometimes try to kick out the window of police vehicles. He testified that she was sitting upright with her eyes open, leaning forward slightly, quote, spaced out as if high on meth, end quote. Constable Doering arrived at the transfer point at 6:37 p.m., and the OPP officers arrived shortly thereafter. According to Constable Doering, he told the female police officer from the OPP that Miss Christian was, quote, high on meth. EMS said no immediate concerns for her health, she was just high, end quote. She told them that Miss Christian had been taken to the hospital the day before. At that point, he approached the rear driver's side door. Miss Christian was now laying on her side. Constable Doering told her to get up. She did not. He believed that she was uncooperative. He started lifting her right arm up and she just sat up with his assistance. The male OPP officer took her left arm and helped her get out of the vehicle. Constable Doering testified that Miss Christian was leaning forward and looking at him. Her eyes were open, her head was up, and she looked like she was standing up on her own. Handcuffs were exchanged. The OPP officers walked her over to their cruiser, though her feet were on the ground. She was not taking full steps, and Constable Doering perceived that she was being uncooperative. The OPP then left the parking lot. When asked why he thought that Miss Christian was being uncooperative, Constable Doering explained that he observed the same things from other people who were high on meth. They are unpredictable, often alternating between anger and calm. He had seen those behaviors before. He believed that she was experiencing the ups and downs of someone high on meth as opposed to being in medical distress. During cross-examination, Constable Doering testified that while he had on many occasions dealt with persons high on methamphetamine, he had never had occasion to have a person assessed or taken them to hospital solely because of the ingestion of the drug. Constable Doering testified that he monitored Miss Christian while she was in his custody and that the idea of medical distress never entered his mind. In cross-examination, he was asked what would have had to happen for him to change his mind, and he responded that he would consider it medical distress if Miss Christian was unconscious or completely limp. Constable Doering testified that Miss Christian's physical condition was different at the transfer point than it had been at the Petro-Canada station. She went from yelling and moving and talking about bombs to saying nothing and mumbling, with no violence or agitation. Constable Doering was cross-examined on a statement to the SIU, in which he said that she was at the point exhibiting, quote, the same demeanor as before, end quote. He explained that what he meant by that was that she was still high on meth. Constable Doering was also cross-examined on whether he told the OPP officers that Miss Christian had, being, quote, looked at, end quote, by EMS. In his statement to the SIU, he said that he had told the officers that she was obviously high on drugs, but that he did not believe her to be in any medical distress. He went on to tell the SIU, I believe I also told them that EMS had looked at her and believed the same as what I had believed with regards to no immediate health concerns for her, and I carried on from there. Constable Doering agreed that he had said to the OPP officers, explaining that when he said that the EMS had looked at Miss Christian, he was referred to the fact that Mr. Hill had looked at her through the front windshield of his vehicle when she was sitting in the back of the cruiser. In the letter written to the SIU after he became a subject officer, Constable Doering stated that at the time of the transfer, Miss Christian, quote, had laid down on her right side across the seat. Her eyes were open and she appeared to be in good health, end quote. Analysis. General principles. Failing to provide the necessaries of life. The offense of failing to provide the necessaries of life is codified within Section 215 of the Criminal Code. For ease of reference, it is reproduced below. 215 sub 1. Everyone is under a legal duty, c, to provide necessaries of life to a person under his charge if that person 1. Is unable, by reason of detention, age, illness, mental disorder, or other cause, to withdraw himself from that charge, and 2. Is unable to provide himself with necessaries of life. 2. Everyone commits an offense who, being under a legal duty within the meaning of subsection 1, fails without lawful excuse, the proof of which lies on him to perform that duty if, b, with respect to a duty imposed by paragraph 1c, the failure to perform that duty endangers the life of the person to whom the duty is owed, or causes or is likely to cause the health of that person to be injured permanently. This offense is animated by the principle that, where a person is in the charge of another, the person having charge has a duty to provide the necessaries of life. Certain relationships and legal duties are described in Section 215 of the Criminal Code. As noted in the Queen and ADH, the essence of the Section 215 offense, then, is that it imposes legal duties arising out of defined relationships. Section 215, as a penal negligence offense, imposes liability on an objective basis. As was explained in the Queen and Peterson, quote, subsection 215 sub 2 imposes liability on an objective basis. The offense is made out by conduct showing a marked departure from the conduct of a reasonably prudent person having the charge of another in circumstances where it is objectively foreseeable that failure to provide necessaries of life would risk danger to life or permanent endangerment of the health of the person under the charge of the other. The personal characteristics of the accused, falling short of capacity to appreciate the risk, are not a relevant consideration. The use of the word, quote, duty, end quote, is indicative of a societal minimum that has been established and is aimed at establishing a uniform minimum level of care. See the Queen and Naglick. As with other offenses, Section 215 is designed to prescribe a uniform minimum standard of care. The, quote, necessaries of life, end quote, include medical attention. See the Queen and SJ. The standard is not one of perfection. For example, a parent or guardian is not required to run to a doctor or hospital whenever illness or the prospect of illness arises. An error of judgment will exculpate, so long as it does not, itself, reflect a marked departure from the relevant standard. The mental element of Section 215 offenses require the Crown to prove, on an objective basis, a marked departure from the conduct of a reasonable prudent person having the charge of another, in circumstances where it is reasonably foreseeable that failure to provide the necessaries of life would lead to a risk of danger to the life of the victim, or a risk of permanent endangerment to their health. See the Queen and Naglick. Criminal negligence causing death. The offense of criminal negligence is codified within Section 219 of the Criminal Code as follows. 219 sub 1. Everyone is criminally negligent who, a, in doing anything, or b, in omitting to do anything that is his duty to do, shows wanton or reckless disregard for the lives or safety of other persons. Sub 2. For the purpose of this section, duty means a duty imposed by law. Like Section 215, Section 219 of the Criminal Code operates by setting a minimum objective standard. In the Queen and Crichton, the Supreme Court of Canada upheld the constitutional validity of the objective standard for liability. The court recognized that factors such as a lack of education and psychological predispositions might be relevant to sentencing but would, quote, serve as no excuse for criminal conduct, end quote, provided that there was sufficient mental capacity to appreciate the risk. McLaughlin J., as she then was, stated, "This is not to say that the question of guilt is determined in a factual vacuum. While the legal duty of the accused is not particularized by his or her personal characteristics short of incapacity, it is particularized in the application by the nature of the activity and the circumstances surrounding the accused's failure to take the requisite care. As McIntyre J. pointed out in The Queen and Tutton, the answer to the question of whether the accused took reasonable care must be founded on a consideration of all the circumstances of the case. The question is what the reasonable prudent person would have done in all the circumstances. Thus, a welder who lights a torch causing an explosion may be excused if he has made an enquiry and has been given advice upon which he reasonably entitled to rely, that there was no explosive gas in the area. The necessity of taking into account all of the circumstances and applying the objective test in offences of penal negligence was affirmed in The Queen and Hundall. The matter may be looked at in this way. The legal standard of care is always the same, what a reasonable person would have done in all the circumstances. The de facto or applied standard of care, however, may vary with the activity in question and the circumstances in the particular case. Criminal negligence is a more serious offense than failing to provide necessaries of life. It is at the, quote, high end of the continuum of moral blameworthiness, end quote, punishes not a state of mind, but the conduct of the accused. Thus, the physical action of the accused is as critical in the determination of wanton or reckless conduct as the mental element, end quote. See The Queen and L.J. The actus reus of the offense of criminal negligence is found in the language of the provision. It requires proof that the accused did something or failed to do something that was his legal duty to do that demonstrates a wanton and reckless disregard for the lives and safety of others. See The Queen and Beattie. The mens rea requires proof that the accused's conduct was a marked and substantial departure from the standard of care that a reasonable, prudent person would observe in the circumstances. The circumstances are those in which the accused either recognized and ran an obvious and serious risk to the life or safety of the victim, or, alternatively, gave no thought to the risk. The analytical distinction between Section 215 and Section 219 was explained by Justice Fish in The Queen and J.F. On the account of alleging criminal negligence, the Crown was bound to show that the respondent's very same omission represented a marked and substantial departure, as opposed to a marked departure, from the conduct of a reasonably prudent parent in circumstances where the accused either recognized and ran an obvious and serious risk to the life of his child, or, alternatively, gave no thought to that risk. I agree with McIntyre J. that where criminal negligence is, quote, piggybacked, end quote, on an alleged failure to provide the necessaries of life, as it was explicitly in Tutton and, in effect, here as well, the analysis may be expected to proceed in two stages. The jury would then consider whether the accused had a duty to protect the child, that is, to provide the necessaries of life, and whether the accused failed in that duty. If so, the jury would be entitled to find that the accused committed an offense under Section 215 sub 2 sub a sub 2. The jury would then be required to decide whether the accused, in failing to provide the necessaries of life, showed a wanton or reckless disregard for the life or safety of the child. If so, the jury would have been bound to find the accused guilty of criminal negligence. If not, the jury could still find the accused guilty of failure to provide the necessaries of life, but not of criminal negligence. The significance of the accused's state of mind. Penal negligence offenses are different from those calling for proof of subjective mens rea, particularly as it relates to the state of mind of the accused. In a traditional subjective mens rea offense, an exculpatory state of mind will serve as a complete defense to the charge. Not so in the penal negligence context, as the test for liability is a modified objective standard. That said, the accused state of mind is not irrelevant. It can serve as a defense if it casts doubt on whether a reasonably prudent person would have appreciated the risks associated with the act or failure to act. Recently, the Court of Appeal for Ontario observed in The Queen and Ibrahim, however, Given that these subjective perceptions must be considered within an objective framework, their acceptance does not necessarily lead to a verdict of not guilty. That is, it may be possible for the trier of fact to accept the accused's evidence about what occurred but find that the marked departure standard has been proved. Still, as Beattie makes clear, the testimony of an accused person about his or her perceptions may be capable of raising a reasonable doubt about whether a reasonable person in the circumstances would have been aware of the risk created by the conduct. Indeed, the wording in Beattie at paragraph 49 directs that where such evidence is adduced, the trier of fact must consider whether this evidence raises a reasonable doubt. This is consistent with the underlying justification for the modified objective test as explained by Justice Sharon in Beattie at paragraph 8. Objective mens rea is based on the premise that a reasonable person in the accused position would have been aware of the risks arising from the conduct. However, where the accused raises a reasonable doubt whether a reasonable person in his or her position would have been aware of the risks arising from the conduct, the premise for finding objective fault is no longer sound and there must be an acquittal. Therefore, in the light of the direction of Beattie, the testimony of an accused person may be relevant to the actus reus of a dangerous driving, as well as the two interrelated mens rea elements. 1. Whether the accused's conduct in question constitutes a marked departure from the standard of care that a reasonable person would observe in the accused circumstances, and 2. Whether a reasonable person in the similar circumstances would have been aware of the risk of the danger involved in the conduct manifested by the accused. Application to this case. Failing to provide the necessaries of life. The actus reus of Section 215 offense is admitted by the accused in this case. He admits that a. He was under a legal duty to provide the necessaries of life to Miss Christian, having taken her under his charge. B. Miss Christian was unable to withdraw herself from that charge by reason of her detention. C. Due to her detention, Miss Christian was unable to provide herself with the necessaries of life, specifically medical assistance. And D. The failure of the accused to provide Miss Christian with medical assistance while she was under his charge endangered her life. The issue in dispute concerns the mens rea of the offense. Constable Doering maintains that his conduct did not amount to a marked departure from the standard of care of a reasonably prudent police officer in those circumstances. On that basis, he urges the court to find him not guilty. I accept that Constable Doering did not subjectively perceive that Miss Christian required medical attention and treatment. This subjective perception is not required to ground liability under Section 215. I have considered to what extent Constable Doering's state of mind raises a reasonable doubt on the modified objective standard of liability. I have concluded that, in the circumstances of this case, neither Constable Doering's testimony nor any other evidence is capable of raising a reasonable doubt on this central issue. Constable Doering's state of mind does not exculpate. Rather, in failing to advert to the need for medical treatment, he turned a blind eye to risks that would have been apparent to a reasonably prudent police officer. I need not determine the precise point at which the duty to seek medical attention was triggered. I am satisfied that it was clearly engaged by the time Constable Doering arrived at the transfer location to meet the OPP. The failure to get medical help at that stage amounted to a failure to provide the necessaries of life and represented a marked departure from the standard of care of a reasonably prudent police officer. The evidence indicates that Constable Doering decided, early on in his encounter with Miss Christian, that he would not be seeking medical assistance for her. In his CPIC communication of 5:50 p.m., he wrote, quote, "It does not appear at this time that Miss Christian requires to be cleared medically at the hospital," end quote. In his testimony, Constable Doering candidly acknowledged that he did not remember whether he wrote that before or after he spoke with Mr. Hill. There is reason to believe that he wrote it before he spoke to the EMS supervisor. Mr. Hill recalled Constable Doering telling him that he was waiting on a response from the OPP. This suggests that the CPIC memo had been written and submitted before Mr. Hill had arrived. In his testimony, Constable Doering referred, on several occasions, to his experience dealing with persons who are, quote, high, end quote, on methamphetamine. He spoke about his years as a cadet when he booked and monitored methamphetamine users in the cells, and his years on patrol when he similarly dealt with persons under the influence of the drug. He testified that he had never taken a methamphetamine user to the hospital merely because the person had consumed drugs. He firmly believed that the use of methamphetamine was not a reason, standing alone, to obtain medical attention. Constable Doering received some confirmation for this view when he spoke to Mr. Hill. I found Mr. Hill to be a less than reliable witness in describing his conversation with Constable Doering, and therefore accept Constable Doering's account of what was said. To recap, Mr. Hill asked about an assessment of Miss Christian, and Constable Doering told Mr. Hill that he did not think she would tolerate an assessment. She was, at that time, yelling and aggressively moving about in the back of the cruiser. Mr. Hill told Constable Doering that, if he assessed Miss Christian, her vitals would be, quote, out of whack, end quote, given her ingestion of the drug. When Constable Doering asked whether he should take Miss Christian to the hospital, Mr. Hill told him that she would just sit there for hours while her condition was being monitored. At that stage, it was not unreasonable for Constable Doering to rely on what Mr. Hill told him. It was apparent that Mr. Hill had no interest in assessing Miss Christian, and his responses fortified Constable Doering's belief that an assessment was not necessary. Had that been the end of the matter, there would be insufficient evidence to ground criminal liability. However, Miss Christian remained in Constable Doering's custody for another 45 minutes, during which her condition deteriorated. By the time they reached the meeting place, Miss Christian was unable to speak, unable to sit up for any period of time, and unable to respond to commands. She was, as described by Constable Billing, lying on the rear seat of the cruiser, moaning and shaking. She could not get out of the cruiser on her own, though she was able to assist in efforts to move her. She was no longer in the alert, albeit highly agitated, state that she had been in at the gas station. Policies, in place at the time, directed police to obtain medical assistance for persons severely intoxicated by alcohol or drug. Policies are not the sine qua non of a duty of care. They do not have the force of law. They can, however, assist in determining what a reasonably prudent officer would do in the circumstances. The relevant LPS policy, Part 9, Chapter A, 2, Sub B, Sub 7, provided that, quote, where a medical condition is in doubt, e.g. severe intoxication by alcohol or drug, end quote, the detainee should be taken to hospital. Constable Doering was not aware of this specific policy, though he knew he had probably read it during his time as a police officer. The Crown's expert witness, Inspector Price, testified that the police officers are unlikely to have intimate knowledge of all 1,500 to 2,000 pages of policy in place at any given time. However, this policy is different. It does not deal with purely administrative matters. It is concerned with the health and safety of persons detained in custody. One would expect that a reasonably prudent police officer, on patrol, regularly engaging with detainees, would be aware of this policy's requirements. Even if this particular policy was not top of mind, judgment and common sense would lead a reasonably prudent police officer to the same place. It is common knowledge that, at certain levels, ingestion of drugs can be dangerous, if not fatal. Overdose can lead to death. Police officers are not medically trained and are not themselves equipped to diagnose or treat toxic effects of drugs. It follows that, when someone presents as severely intoxicated, their health is in doubt and medical attention is required. Even paramedics are told to take persons to the hospital if their vital signs are irregular, as can occur in the case of drug use. This is not to say that all persons intoxicated by drugs must be taken to the hospital. There will be cases, perhaps many, in which persons affected by drugs will not need medical attention. Just as a parent is not required to run to a doctor whenever illness or the prospect of illness arises, a police officer is not required to take a detainee to hospital at the slightest indication of intoxication or other health concerns. However, Constable Doering acknowledged that Miss Christian was very high on methamphetamine, as evidenced by her highly erratic behavior at the Petro-Canada station. Constable Doering insisted that his testimony that her level of intoxication was, quote, average, end quote, in that it was not unlike the levels of intoxication that he saw on a daily basis. Even if that is the case, the risks of severe intoxication are not reduced merely because one has encountered those risks before. nor is it an answer that Constable Doering had never taken a person intoxicated by methamphetamine to the hospital for that reason alone. In her submissions for the Crown, Miss Bodwin cited the example of a motorist who routinely drives 50 km per hour above the speed limit and justifies his conduct by saying that it has never resulted in harm. The issue is not actual harm, but risk of harm. The fact that the risk was undertaken in the past without incident is quite beside the point. Constable Doering placed considerable reliance on the information and advice he received from Mr. Hill. Constable Doering was reasonably entitled to rely on what Mr. Hill had said at the time he said it, but this was not a permanent medical edict. It was a full 45 minutes later that Constable Doering reached the transfer point, by which time Miss Christian's condition had deteriorated. She was no longer upright in her seat and aggressively moving and yelling. She was prone on the seat, moaning and shaking, and unable to get out of the car on her own. Her condition had changed, and it was obvious that she was getting worse, not better. Moreover, it is not clear that Constable Doering actually monitored Miss Christian's condition during this 45-minute interval. He could not recall if he spoke to her while she was in the back of the cruiser. He testified that he saw her sliding down in her seat on 3 occasions. He directed her to sit up, and she did. He stopped the car at one point, but not because he wanted to check on Miss Christian's well-being. He was concerned that she might have slipped out of her handcuffs and did not want her punching the cruiser's window. Finally, Constable Doering testified that, while en route to the transfer point, Miss Christian said something that he could not hear because the windows were down and the wind was loud. This did not trouble him, and he took no steps to find out what she had said. Constable Doering was focused on getting Miss Christian to the OPP and on making sure that her detention remained secure. It seems that he was far less concerned, if he was concerned at all, with her medical condition. Police officers perform a critically important function in our communities. Their jobs are immensely challenging. Police are often faced with volatility and uncertainty. They are often called upon to make split-second decisions only to have those decisions minutely scrutinized in the antiseptic column of the courtroom. Police on the street do not enjoy the luxury of the leisurely reflection available at a criminal trial. In this case, however, Constable Doering did have time to reflect on the situation at hand. There was no temporal or tactical urgency. Miss Christian was not at large. She was secured in the back of a police cruiser. Constable Doering was not distracted by other duties while he was with Miss Christian. Presumably, he had time to consider his options and, if necessary, reach out for advice. Calling for medical assistance would have, at worst, delayed the transfer to the OPP. Yet the OPP was not in a rush, as they had declined to return on the warrant the day before. In short, there was no operational contingencies that counterbalanced or displaced the duty to seek medical assistance. Why, then, was medical assistance not obtained? It is difficult to answer this question. Although it may not have been legally required at that point, it would have been a simpler matter to have Mr. Hill, or one of the attending paramedics, examine Miss Christian while at the Petro-Canada station. Thereafter, it was a simple matter to contact EMS. Mr. Nicol, for the Crown, posited that Constable Doering was anxious to divest himself of responsibility for Miss Christian. The Crown alleges that there had been medical intervention and might have discouraged the OPP from returning on the warrant, as it had done the day before. The Crown alleges that Constable Doering ignored the risks in part because he wanted to complete the transfer of custody without interruption. There is some evidence to support this theory. Constable Doering was aware of the following. A. Miss Christian was a drug addict. B. She was high on methamphetamine. C. She was creating difficulties for motorists and pedestrians in a high-traffic area. D. She had been high on methamphetamine the day before. E. She had created similar difficulties the day before. F. Her conduct had engaged police resources the day before. G. She was wanted by the OPP. And H. Once transferred to the OPP, she'd be less likely to cause difficulties for the LPS. Constable Doering's exchange with Constable Park over the mobile terminal suggested that Miss Christian was seen as something of a nuisance and would become less of a problem once she was in OPP custody. Constable Doering did not waste time in traveling to the transfer point. Once the warrant was confirmed, he left quickly and traveled to a location closer to the OPP detachment than was originally planned. Finally, the statements made by Constable Doering to the OPP officers at the transfer point seemed calculated to prevent EMS from being summoned until well after Constable Doering had departed the scene. Those statements are the crux of the Crown's case on criminal negligence, to which I will now turn. Criminal negligence. The Crown alleges that Constable Doering deliberately misled the OPP officers about Miss Christian's condition. The Crown says that he lied to them when he intimated that Miss Christian had been assessed by EMS, and further, that he lied to them when he told them that she had been in the same condition throughout his time with her. These statements led the OPP to believe that there was no immediate need of medical attention and delayed the eventual call to EMS. The Crown alleges that this conduct demonstrated a wanton and reckless disregard for Miss Christian's life, and that it was a contributing cause of her death, and that it represented a marked and substantial departure from the standard of care. Constable Doering had a duty to convey accurate information about Miss Christian's medical condition to the officer, assuming responsibility for her custody. He did not do so. The question is whether he deliberately misled the OPP officers. Having carefully considered the issue, I must conclude that Constable Doering knowingly misled the OPP. There is no other rational interpretation of the evidence. Constable Doering admitted telling the OPP that EMS had, quote, looked at, end quote, Miss Christian. When confronted with that statement in cross-examination, Constable Doering insisted that what he meant was that Mr. Hill had, in the literal sense, viewed Miss Christian through the police cruiser's front windshield in the plexiglass divider. That assertion stretches the bounds of credulity. Constable Doering had to know that, by saying that Miss Christian had been looked at by EMS, he was conveying that she had been, in some fashion or another, assessed by EMS. This is particularly so given the follow-up assurance that she did not need medical assistance. Constable Doering struck me as an intelligent individual with some years of experience as a police officer. It is fanciful to suggest that he either meant to convey a pure visual observation or that he believed that his remark could be interpreted in that fashion. The statement that Miss Christian had been in the same condition throughout her detention was also manifestly untrue. Constable Billing could not recall the precise words used by Constable Doering. He might have said her demeanor was the same, or that her behavior was the same. In either event, the statement misrepresented a critical fact. As already noted, Miss Christian's condition had changed quite dramatically since the time Mr. Hill had, quote, seen, end quote, her. Constable Doering's statements created a risk that the OPP would not appreciate the gravity of Miss Christian's condition, and that medical assistance would be even further delayed. This increased the risk of Miss Christian's life and represented a wanton and reckless disregard for her well-being. I am satisfied that this conduct was a marked and substantial departure from the standard of care of a reasonably prudent police officer. Final observation. The evidence in this case suggests that stereotypes and generalized assumptions played a role in the events leading to Miss Christian's death. Constable Doering had definite opinions about how persons on drugs and persons addicted to drugs were likely to behave. He had a definite opinion that drug use alone would not be a factor calling for medical intervention. These opinions formed the lens through which he perceived the events in this case. He viewed everything, including signs of medical distress, as nothing more than the stereotypical conduct of another drug user. If Miss Christian was aggressive, it was because she was high on methamphetamine. If she was silent and apparently non-compliant, it was because she was high on methamphetamine. If she was lying on the seat, moaning and shaking, then she was just, quote, riding out her high, end quote. It is not clear what, if any, observations would have prompted Constable Doering to call EMS. When asked that question in cross-examination, Constable Doering found it difficult to answer, though he acknowledged that EMS should be called if a drug user is limp and/or unconscious. In short, Constable Doering had preconceived notions about drug users, and he held fast to those notions when dealing with Miss Christian. Rather than molding his theory to fit the facts, he seemed to have molded the facts to fit his theory. These assumptions may have also impacted the OPP officers who dealt with Miss Christian. It is striking that, when police arrived at the Elgin detachment with Miss Christian, they perceived her non-responsiveness to be indicative of non-compliance. She was told to get out of the cruiser. She did not react. Officers believed that she was being obstructionist, not wanting to go into custody. She had been identified as a drug user who was known to London police. This informed the officers' interpretation of her conduct. This interpretation, questionable on its face, becomes inexplicable when one sees the video footage of Miss Christian being dragged along the floor into the cell area. She is limp and unmoving. She is unconscious. The evidence is that she was making very little sound. Even the moaning had abated. The EMS paramedic evidence leads one to believe that her eyes had been open, unblinking, for some time. In this condition, it is hard to imagine that she could have been conscious of a command, let alone capable of defying it. The OPP called for EMS, but this was close to 17 minutes after Miss Christian arrived at the detachment. Even at that stage, the OPP indicated the situation as non-emergency, quote, no lights and sirens, end quote, call. This illustrates the power of the stereotype and its resistance to correction. Finally, Miss Christian was of Indigenous heritage. There is no suggestion that this played any role in the decisions made by the police in this case. Nonetheless, it has been observed that Indigenous women and girls are particularly vulnerable to stereotyping. This includes stereotypes relating to alcohol and drug abuse. See the report of the National Inquiry into Missing and Murdered Indigenous Women and Girls. On this point, also see the Queen and Barton. Conclusion. Miss Christian was a suspect wanted on an outstanding warrant for failure to comply with a recognizance. She was a person who was creating a disturbance in a public area of London while intoxicated by drugs, and who had done the same the day before. However, she was also a vulnerable woman of Indigenous heritage who was in dire need of medical attention and who, by reason of her physical condition and her placement in custody, could not secure it on her own. I am satisfied that a reasonably prudent police officer would have appreciated the need for medical assistance at the time of the transfer to the OPP, if not before, and would have been aware of the risk that failure to obtain such medical assistance would endanger Miss Christian's life. I find in relation to Section 215 of the Code that Constable Doering failed to provide Miss Christian with the necessaries of life and demonstrated a marked departure from the standard of care of a reasonably prudent police officer. I am further satisfied that, in providing the OPP with erroneous and incomplete information about Miss Christian's condition, Constable Doering demonstrated a wanton and reckless disregard for Miss Christian's life. His conduct created a risk that medical assistance would be even further delayed. It represented a marked and substantial departure from the standard of care. It was a contributing cause of Miss Christian's death and grounds culpability under Section 219 of the Code for criminal negligence causing death. For these reasons, I find that the Crown has proven the essential elements of both offenses beyond a reasonable doubt. Constable Doering shall be found guilty on counts number 1 and number 2 on the indictment.
Legal Listening is founded by Zach Battiston and Carly Lyons. Hosted by Zach Battiston, Carly Lyons, and you, our listeners. Executive produced by Zach Battiston, Carly Lyons, and Anthony Radamile. Audio engineering by Anthony Radamile. Graphic design by Julie Lundy at julielundyart.com. Music by Matt Radamile at radandkel.com. We're always open to ideas, suggestions, and of course, guest readers. Check us out at Legal Listening on Twitter and at legallistening.com. We'll talk to you next time.